Good morning. I'm sure you have divided up time between you, but in order to rock that boat very slightly, having read widely, we would be grateful if you would address ground one and that we hear argument on both sides in relation to that, and we'll see where we stand at that point.
Right. Okay. Thank you very much, my lady. My lady, I appear on behalf of the appellant, together with Mr. Kwok. The respondent is represented by Mr. Knox, King's Counsel, and his junior, Mr. Goldblatt. In the light of what you say, we'll deal with matters in that way. Also, in the light of, should we get there, in the light of recent announcements from the Lady Chief Justice, Master of the Rolls and Heads of Division regarding oral advocacy by junior members of the bar, Mr. Kwok will deal with ground 3 of the respondent's notice insofar as necessary. That's page 32 to 36 of our skeleton submissions. Also, having reviewed the law in preparing for this appeal, my lady, one can strike through paragraphs 75DE and 76 of our skeleton submissions, and those are the points regarding the presumption of similarity in relation to one point in relation to Brownlee. We still stand by the submission that there's been no error of law by the learned deputy judge, and that this is a wholly unsuitable case and situation within which to apply the presumption. But there was a misunderstanding of one passage in Brownlee. As I say, it doesn't actually affect, but I just wanted to flag that up at
Mr. Blaker, could you give me those paragraphs again?
Yes, of course. So if one turns to 75.
Yes.
And it's 75D.
Thank you.
It's actually the point that it only ever operates unless and until evidence of foreign law is adduced. That is correct. And that part is still correct. So it's really the second part of that paragraph, and then it's E, and then 76. Those actually fall away in the light. But I'll develop that argument at an appropriate time, should it be necessary. Also, the appellant raises an issue regarding the permission that the respondent requires in relation to ground 3 of the respondent's notice. And again, it may be that in the light of dealing with the main part of the appeal, that can be dealt with at an appropriate time if necessary. Finally, you'll see at page 250 in the core bundle, there is a list of issues that have been prepared by the parties. Of course, they're there to assist the court, but I would very much hope that the issues will become rather straightforward through the course of my submissions. I'd now like to, before actually going on to the particular grounds, in particular the way I approach ground 1, it is necessary in my submission, my lady, my lords, to set out some introduction as to what this dispute is actually about. The appellant's case is that the key finding in paragraph 190 of the deputy judge's judgment was wrong for a number of different reasons. And in particular, it is our case that it leads to a completely uncommercial and somewhat absurd result. And I shall highlight throughout the course of these submissions that lack of commerciality and absurdity. Unless you wish me to do so, I will not take you to the actual that actual paragraph of the judgment at this point in time.
It's just a summary of where he's got to.
It's a summary, exactly.
Yeah.
Yes.
So you saying it's so uncommercial and absurd it cannot be what the parties intended? Is that
that's right, my lord, and I will develop that during the course of.
But not that the parties did in fact intend something else.
No, it's that the objective party to that profit share agreement could not have intended that a sale of the shares in Soto would lead to no profit share for Mr. Ortiz-Patino. It's important in this case to set out and introduce the corporate structure. The appeal concerns the sale of the Valderrama golf course in Andalusia in southern Spain. It's regarded as one of the world's leading golf courses and has been the host of many major tournaments, including the 1997 Ryder Cup. The fact that the course would and continues to host leading tournaments, and those that are televised, is not there just simply as background information, but is a relevant and material fact in this case. The appellant's father, Jaime Ortiz-Patino, was the founder and the owner of the golf course and much of the surrounding land. For the sake of simplicity, during the course of this appeal, I shall refer to him as J.O.P. J.O.P. died in January 2013, actually very shortly after the profit share agreement and the sale and purchase agreements were entered into in the October of 2012. J.O.P. had two sons, Carlos, the appellant, who I shall refer to as COP, and Felipe, FOP. The structure of the corporate and land holdings is set out in paragraphs 4 to 6 of our skeleton submissions. And you will hear in particular about two Spanish companies, Valsa and Vesa. And I set those out in paragraph 4, subparagraph 1. But let me explain. Vesa owned plots of land and trademarks. Valsa was the company that owned also plots of land, including the actual golf course itself. And in addition, it also owned trademarks. Soto was a Swiss company which owned 100% of Vesa and 94% of Valsa. The remaining 6% of the shares in Valsa were owned by the Real Club de Valderrama, RCV. That's in effect a members club, and those 6% of the shares are owned by the members themselves. And as I shall explain, my lady, later on in these submissions, there were, in greater detail, there were significant problems with the club members and the relationship between JOP and RCV and its members. The members had preferential rights and preemption rights over any sale of Valsa shares, and they were particularly hostile to JOP. Relatively nearby, but not contiguous to this land, there was further land owned by another Swiss company called Campo. Campo, in turn, owned a Spanish company called Valderrama 07, which I shall refer to in these proceedings as VO7, and it itself owned land at Castellar de la Frontera, known as the Castellar land. VO7 also owned trademarks, and it was JOP's plan to develop the Castellar land into another top-quality golf course, presumably my understanding is at the same sort of standard as the Valderrama golf course. Now, this appeal does not concern the Castellar land directly, or VO7 or Campo, but if you can turn to page 3, page 255 and paragraph 6, we've set out there an organogram that sets out pictorially the ownership of the various Swiss and Spanish companies and the land itself. In 2010, the Stripe Group, which is referred to often as TSG, headed by David Spencer, who was well known within the golf world, TSG was interested in buying all the Valderrama companies. And what is particularly important for the purposes of this appeal is that at that time in 2010, TSG and David Spencer carried out extensive due diligence on the Valderrama companies. That included obtaining reports from lawyers, DLA, and accountants, KPMG. Now, I am going
Just to be clear, when you say the Valderrama companies, you're actually talking about Soto, Vesser, and Valser.
Yes.
You're not talking about Campo and VO7.
No, they also carried out due diligence on that as well, because they purchased everything. So at that time...
that's not paragraph 48 of the judgment. Paragraph 48 of the judgment to which you refer, I think, talks simply about Soto.
Yes, well, it's not particularly relevant, my lord, to the fact that they actually do that.
Okay, but just for terminology purposes,
yes,
if you're going to talk about Valderrama companies, you're for this purpose restricting yourself to the right-hand side of the organogram.
That's right.
Right.
Yes. Yeah. So if we turn to paragraphs 48 and 50, the learned judge sets out there the some of the work that was actually carried out at that time. In particular, the fact that DLA Piper, DLA provided general legal due diligence, KPMG financial and accounting due diligence, and then he at 50 sets out some of the key points that the DLA Piper report sets out. And we see at Roman 1, it identifies the preferential rights of the holders of B shares, that's the RCV members, and the fact that they were, their consent was required before the payment of dividends out of the proceeds of sale of the golf course. They were entitled to 50% of the value of the liquidated assets in the case of a winding up of Valser, and their approval was required should Valser's debt exceed 50% of its share capital. At Roman 2, the report noted the preferential acquisition rights of RCV to acquire the golf course and the trademarks under the framework agreement. At number 3, that there was already a letter of complaint sent by members of RCV to FOP as chairman of the club regarding charges over the golf course. At Roman 4, the existing conflictive relationship, and there that there was even the risk of future litigation. And then at Roman 5, over the page, the pledge of Class A, C and D shares and the debts that they were simply noted, and that Valser had a negative working capital. 51 refers there to the KPMG report. In the supplemental bundle, the DLA and KPMG reports are set out in part, but the relevant parts are set out. If one turns to 104 in the supplemental, and we we see a legal due diligence report dated the 20th of September 2010 called Project Cruise. May I draw your attention at page 109 to the middle of the page, where it says, the paragraph where it says the vendor has been provided with a Spanish legal opinion on the triggering of the preferential acquisition rights, which specifically states that instead of a direct sale of Valsa shares, the shares of the company holding Valsa's share could be sold. Soto, in this case, the club, and there it's referred to as CGV rather than RCV, or Class B shareholders should allege the existence of a fraud to their above-mentioned preemption rights, and 2, a letter by which CGV serves notice reminding the vendor of CGV's preferential acquisition rights, which could give rise to litigation. And then we see over the page, at 110, about halfway down the page, as described in other sections of this report, although the transaction will not trigger the aforementioned preferential acquisition rights. So again, the legal opinion, both from the Spanish lawyers and that adopted by DLA, is that a sale of Soto would not trigger that, but they flag up the possibility that a Spanish court may consider this transaction fraudulent and eventually rule in favour of the members. It wasn't.
What do you derive from those two passages?
Well, what I derive from that, my lord, and what I'm going to develop there's two things in particular. One is the extensive due diligence that took place by the strike group and that the judge found had been adopted by the respondent in this appeal. So that the respondent was well aware of these particular issues. And secondly, and most importantly, my lord, is the fact that the parties to the contract and to the profit share were aware that the only way to sell the club, the golf course, and the Valderrama companies was without triggering the preemption rights and trying to avoid litigation, was through a sale of Soto rather than through a sale of either the land itself or through Valsa or Vesa. I mean, Valsa is the one that actually owns the golf course. So I'm just simply setting out, my lord, at this point, in terms of, because there is this strange gap here between what happens in 2010 and then the actual purchase in 2012. And so it's very important that that my lady and my lords are aware of what due diligence and what extensive due diligence took place before the acquisition. And can I just draw your attention as well to two paragraphs further down on 110, where that paragraph where it says...
Sorry, can I just retreat a little bit or go back? Where do we find the actual preferential rights of the holders of the B shares in Valsa? That's what's referred to here, is it?
Yes. I don't think
Where are they?
I don't think we actually have that in a document that's before the that was either before the before this court. Mr. Knox may.
It was before the judge below. Yes. I think the judge summarised it. I can't remember where.
I mean, it's not.
Is it? I mean, what are the preferential rights that would have been triggered that everybody was concerned about? Are they as identified in paragraph 50? So paragraph 1.
Yes, so it's the ability to also purchase the shares for at 50% of their value. And what?
Well, sorry, that's not what he says at 50.1. Sorry, that's why I'm just trying to pin them down, because if you're going to place reliance on something that everybody is said to know about the triggering of avoiding the triggering of preferential rights. And I think your argument is that everybody knew that could only be avoided if the shares in Soto were sold.
That's right.
And that's why you say that's part of the matrix.
Yes.
it would be useful to understand what
Yes.
preferential rights are actually, as it were.
Can I come back
there.
to you, my lord, on that, and just because I will want to try and I'm sure that I can actually find either a document or where there is a better reference to what the preferential rights actually are.
Because as reported at paragraph 50.1, if that's the sole extent of it, I'm not at the moment quite clear why, for example, the sale of a plot of land at the side of the golf course would trigger.
Well, it's
Say.
well, it's the sale of. It would be the sale of the golf club.
No, but
and the sale of Valsa.
But as I understand it, as well as the golf course, these companies owned plots of land around the golf course.
That's right.
And those plots of land could have been sold. And the dots I'm not able to join at the moment is if a plot of land around the golf course had been developed and sold, not the golf course,
yes,
but a plot of land around the golf course, what would it have triggered, if anything? That's just those are the dots I can't join at the moment.
As I say, if I can return to that, my lord, and I will answer that question in a little while. And then page.
Can I just ask one other question?
Yes, of course, ma'am.
The passage you showed us on page 110 in the
Yes.
DLA report talks about the transaction with a capital T. Can you summarise what the transaction was? Was that a sale of that was the original sale to the first purchaser, was it?
Well, of course, this is anticipating a purchase by the Strike Group of the Valderrama companies.
So the shares in Soto.
Yes, it's the shares in
Yeah.
Soto, and if one looks after that, it says, i.e., the sale of Soto shares.
Yes.
But if one looks on page 107
Yes.
in that due diligence report, transaction is first defined there. It says potential acquisition of the entire group of Valderrama companies, the group which carry out the golf-related business at the particular place, thus owning various golf courses and other related assets. So it's very widely drawn.
It goes on, the transaction should be carried out via the acquisition of the entire share capital and shares of the holding company, Soto.
Yeah.
Yes.
So that's what seems to be envisaged.
Yes.
It is the acquisition of the share. It's not very well
Yes.
together,
No.
but it seems to be the acquisition of the shares of Soto.
Thus indirectly acquiring Valsa. These are
Valsa,
separate.
Vesa, and the land itself and the
Yeah.
trademarks, yes. And then if we turn to page 102, 100 is the KPMG report. And again, we only have the key extracts that are relevant for the purposes of this appeal. Page 102, there's a second column, or row, I should say, indirect partial acquisition. There's a tax-free capital gain upon the sale of Soto that is flagged up. And similarly, can I draw your attention over the page at 103 to the fourth bullet on the left hand, where it says the overview of the tax treatment of Soto for direct taxes. And again, there's a benefit that is set out. It benefits from the holding company regime for cantonal and communal tax purposes. the strike group was not able to complete, and on a number of occasions the agreement was deferred. And in 2012, Mr. Spencer introduced Richard Moxon, the director of the respondent, to JOP. There was, at paragraph 108 of the judgment at page 57, an important finding of fact, that the due diligence reports were made available and relied upon by MGI, the respondent. I will leave you, my lady and my lords, to read the whole of paragraph 108. And that was accepted. Sorry, I don't want to run on if you're still reading. That was accepted by Mr. Moxon. We see this not only in the judgment, but we also see this in the transcript. There's some very limited parts of the transcript in this case, and we see this in the supplementary.
Why do we need the transcript if the judge has made a finding of fact? That's a finding of fact.
Well, my lord, that's right. He goes even further in my submission. He goes even further than is set out by the learned judge.
Well, how do we know the judge accepted it?
But the judge did accept it. Yes, that's right. Also, what we see, and I do want to draw your attention to page 221 in the supplemental bundle, is a document which I do say is also relevant for two purposes, not just the due diligence, but this question, the whole question of contractual interpretation. We see here a letter or a document at page 220, and it's stamped by DLA Piper. It's before the acquisition actually takes place in October of 2012. It's dated the 25th of September, 2012. And what we see at page 221, it's not a terribly good copy, but we see in number 2 the offer. It says, as you know, MGI Gulf Leisure Opportunities Fund, MGI, has a thorough knowledge of the assets held by Soto, Valsa and Vesa. We've done intensive legal and financial due diligence on the securities provided by BANIF, by Mr. Ortiz-Patino. Accordingly, our offer is as follows. And so that's the first point in relation to the knowledge of, and it's signed, I should say, over the page by Mr. Moxon at page 222. But can I also draw your attention to what is said at the bottom of 221 throughout the process of this transaction?
Sorry, where are you reading from? Oh, I see, under the third heading.
Club de Golf Valderrama. Throughout the process of this transaction, it's become increasingly more evident that the relationship between the members of CGV and Mr. Ortiz-Patino has deteriorated to such extent that it's beyond repair. MGI do not believe that this transaction or any transaction we have discussed previously has triggered the preemptive right as contained in the lease framework agreement between CGV and Valsa. That being said, we'd like to nurture a friendly and proactive relationship between the members. And what I say there is that they were discussing the purchase of the Soto shares, and Mr. Moxon and MGI would have been well aware at that point in the September of 2012 that a purchase of their belief was that a purchase of Soto would not trigger the preemptive rights.
Those are the preemptive rights you're going to come back to.
That I'm going to.
As to what they actually were.
Yes.
Because that talks about preemptive rights under a lease framework agreement.
A lease framework agreement, yes.
And
the
which
lease framework
seems to be
agreement,
different to preemptive rights as holders of B shares, or unless, again, you can join the dots for me.
Yes. Now, the framework agreement is actually, my lord, referred to in paragraph 24 of the judgment, page 29 of the core bundle. And what we see at Romans 6 is that Valser agreed not to transfer the title to the leased facilities, i.e. the golf course.
I'm sorry, Mr. Baker, which paragraph of the judgment?
24,
Thank
my
you.
lord, page 29 of the core.
Thank you.
And I'm looking now at Romans 6. And it's Valser agreed not to transfer the title to the leased facilities, i.e. the golf course, to a third party during the term of the new lease. And the lease runs until June of 2050. We see that in Roman 1. Without first offering RCV the opportunity to purchase the title on the same terms. If RCV exercised its right and purchased the title of the golf course on those terms, Valser was to be put into liquidation, and the holders of the B shares in Valser would be entitled to 50% of Valser's surplus assets. In the alternative, Soto could agree to sell the A, C, and D shares in Valser to RCV at a price equal to 50% of the price offered by the third party for the golf course, less Valser's indebtedness.
Right, but that's dealing with the golf course.
That deals with...
And you quite understand, as is the case with every piece of golf club litigation I think I've ever encountered, that the members of the golf club that play on the course are always concerned to ensure that the golf course isn't sold because they want to continue to play golf, because that's what they do. But that doesn't relate to anything other than the golf course, at least not on its face.
Well, my lord, as I'm going to develop during the course of these submissions, it very much goes to the heart here because of the words any and all in the profit share agreement. And the parties, in my submission, the parties' clear understanding was that all of the assets, this wasn't a case of just nibbling away at selling the odd plot of land around the side of Valderrama Golf Course, but this was a case of, which is what actually ended up happening, was all of the assets being sold, and that was anticipated in the profit share agreement that in the event of either any...
Sorry, all of the assets weren't sold?
Well, they were eventually in 2015 because they were sold to Zagaleta for... So the golf course, it may be that I'll have to develop this as I... It will become clearer as I develop my submissions, but the whole point is, my lord, that this is that what we say is that upon a sale of all of the assets, i.e. the golf course and the surrounding land and the trademarks, the profit share agreement was triggered. It will become much clearer once I actually get to the heart of looking at the profit share agreement itself, but I felt it necessary to, which I've nearly come into the end of, to actually set out the background and the historic background here. So I was looking at that document at page 221 of the supplemental.
And also perhaps little 7 was relevant. Valser agreed not to transfer the trademarks to a third party during the terms of the new lease without first offering RCV.
Yes, I must not forget the trademarks. They've become a rather subsidiary matter of this appeal, but actually they are, of course, important, and the trademarks of a leading golf club could be extremely valuable.
So just to be clear, because I just thought I'd moved into a parallel universe. What was sold to Zagaleta was Soto.
Was Soto, yes.
Yeah, but you
said it was
you said it was all the assets.
But Soto owned...
No, but what was sold were the shares in Soto.
The shares in Soto, yes.
Right, so it's not
Well,
the sale of the assets.
well,
I asked you about the golf course, about plots of land. And
Yes.
that's where you're having a debate, and then
Yes.
you just said that's what was sold to Zagaleta,
No.
and it isn't.
well, we say that indirectly, and that it triggered the profit share agreement because that sale of Soto that everyone knew.
That's why we're here.
That's why we're here.
Answer that
That's why we
question.
say that the sale of Soto that everyone knew that the only way that ultimately the
sorry, I just thought I'd moved into a
no,
parallel.
sorry, my lord, if I didn't make myself clear.
Well, I thought I'd moved into a parallel universe in which, in fact, there had been a sale of real,
not at all. It's the sale
tangible land.
No, it's the sale of Soto.
No, right. Okay.
Yes. On October, I should just say at this point, although Mr. Knox will be able to deal with this himself, is that in his skeleton submissions, he has asked the court essentially to revisit this question of knowledge and attribution, but we say those matters were firmly decided in favour of the appellant and our findings of fact that the court should indeed accept. Also, that document, I should say, the one that I've just drawn your attention to at 221 of the supplemental bundle is one that the respondent has asked to be included, albeit we say it primarily assists the appellant. On the 18th of October, there was the novated, 2012, the novated agreement, and the profit share agreement was signed on the same day, and we see that in tab 1 of the supplemental bundle. That's page 2. And I'll come to this in a little while. The MGI owns the Valderrama companies for just over 3 years. And then there is a share purchase agreement with Zagaleta on the 30th of October 2015, when they sell the shares in Soto for roughly 20.6 million euro, and the shares in Campo for €1. What we say is that MGI only ever sought purchasers for Soto and Campo, and there was no evidence before the judge, save for what may be said by Mr. Moxon in his witness statement. There is certainly no documentary evidence to the contrary. A claim was issued on the 22nd of December 2020. And the first time that the defendant denied liability on the basis of contractual interpretation of clauses in the profit share agreement was in the defence, the original defence dated the 18th of February 2021. We see that again in the core bundle at tab 6, page 136, and we see that in paragraph 20 of the defence, page 140. And there it said that the sale was not of the Valderrama companies, but of Soto and Campo, which owned shareholdings in the subsidiary companies. This notably was not raised as an issue in any pre-action correspondence. And we also see, and I'm going to refer to it later on in greater depth, but it's whilst we're at the pleadings and statements of case, if one turns to the RFIs, the defendant's response to request for further information of 188.
So why is this relevant? I mean, they're either right or they're wrong. I mean, this isn't a question of credibility where a factual question is raised late and the inference is, well, you've only just thought of it and it isn't the fact. I mean, this is a legal argument on interpretation. It's either right or wrong, no matter how late it was that somebody got to it.
I accept that, my lord, and that's right. But what I do say is where this goes to is these questions, and one sees the objective intention of parties that actually Mr. Moxon, and we see when I look at some of the evidence that Mr. Moxon, in terms of the factual matrix and how he understood.
That's completely irrelevant. It's not the factual, it's not the objective intention of the parties. That's a, what's the word? That's internally inconsistent. It's what the reasonable objective bystander would attribute to the parties because of the words that they have used.
But of course, my lord, knowing the factual matrix that existed at that time.
Right.
And so one can't look at these words without understanding and knowing the difficulties that existed in terms of, for example, the difficulties with the club members and those rights of preemption. And my point is that I will develop during the course of these submissions is that those are very relevant factors in this case that I say that the learned deputy judge didn't take into account, and therefore avoided particularly the commerciality and the commercial real what was really happening on the ground, and also effectively missed out a number of factors.
Right, but the point I was picking you up on is I thought you were developing a point was basically look how long it took for the respondent to happen upon this defence of interpretation, and that's where your submission seemed to be headed. And I was just trying to sort of understand what legal framework you were trying to bring to bear on that, as opposed to a sort of, if I dare suggest, jury point.
No, I understand that, my lord. But can I just take you, my lord, to the point at 212?
Sorry, we're at 212
in the core. And one sees there at reply 9C that in October 13, the defendant decided to sell the real estate assets by whatever means possible, whether by selling the shares in Valsa and Vesa or the plots of land themselves. Now again, what I say is that any objective understanding of this agreement, a party would understand that selling Valsa or Vesa or indeed Soto shares amounted to selling the real estate assets.
I'm sorry, could you repeat that and take me back, because I had difficulty with my bundle.
I'm sorry.
I'm at 200 and...
212, and I just asked you to read and see
Yes.
what's said there in the first three lines.
Yes. And your submission that you just made was...
And the submission that I'm, and it will fit in with the other grounds, in particular ground 3 of the our third point, is that shows the clear understanding of Mr. Moxon, signed with the statement of truth, Mr. Moxon, during the course of the trial, that on any objective reading, a sale of Valsa and Vesa was a sale of the real estate assets. And I say that if its sale of Valsa and Vesa was a sale of the real estate assets, then so was a share sale of Soto, that was the ultimate holder of that share, of those shares.
So you're saying that we can derive something from a response settled in 2022 by Mr. Knox, attested with a statement of truth by the defendant's solicitors, that we can in some way derive from that one sentence what the parties must have meant when they entered into the agreement in 2012.
Well, it's another factor, my lord, in terms of a whole bundle of factual matters, in terms of the factual matrix, that I say that the learned judge ignored.
Which factual matrix principle of law allows you to look at events occurring after an agreement is entered into as a means of interpretation of the agreement?
Well, I don't say that it's after, my lord. I say that it's before. Back when they enter into this agreement in 2012.
October 2013 is after October 2012.
Yes, but what I say is that they were aware of the difficulties and how one would sell all the assets, because it's any and all, and how all the assets could be sold, and that they were aware of that before they enter into the profit share agreement. Of course, I'm not suggesting that the court can look at matters that post-date the entering of the agreement in October 12. I'm saying that before that, this was something that the parties were perfectly aware of.
You're driving something, but from Mr. Knox's choice of language, are you? That he says that one way of selling the real estate assets is to sell the shares in Valsa or Visa.
And what I say, and I will come to this when it comes to the appropriate time, my lord, is that actually this was a matter that was accepted also, firstly, that the answer, it's a concession made in a pleading, so, and secondly, that these were matters that were put to Mr. Moxon, and Mr. Moxon accepted that the way to sell all the assets was through a share sale of Soto. And that was clearly the understanding, and to deal with Lord Justice Snowden's point, the clear understanding before they entered into the profit share agreement. Can I turn now to the profit share agreement itself? And in particular, I'd like to take you to clause 3.
Page.
5, supplemental bundle, my lady. So what we see here is the sale of the Valsa or Vesa real estate assets. The purchaser at 3.1 will use reasonable endeavours to identify third-party buyers for any and all of the real estate assets. It's accepted that all means includes the golf course. So they were under that obligation to identify purchasers for those assets at the best saleable price. What we then see at 3.2 is that if after the effective date any real estate asset is sold, now just pausing there, this agreement's not very well drafted. There are a number of ambiguities in here, and the word sold and transferred appears to be used interchangeably throughout. And again, I say that is particularly important for the purposes of this appeal, because a sale of the real estate asset, if that means just the land, and if the meaning of sold is either the transfer of the title or a transfer of shares in a company that holds owns the land, or a company that owns a company that owns the land, that satisfies the meaning of the word sold for the purposes of this clause. So if after the effective date any real estate is sold to a third party unconnected or an arm's length purchaser, then they have to pay net profit. And the net profit is essentially a 91% 1% split. How is that to be calculated? Well, 3.3 sets out the framework for how net profit should be how the calculation should take place. And we see at point 1 a deduction for bank facilities, at point 2 a deduction for commission, point 3 tax, at point 4 professional and legal accounting fees, and point 5 any direct costs in relation to the development of any real estate asset. 3.4 deals with the way JOP was to receive the money, and there it says that payment was to be in 30 days. Now there's an express reference there to Valsa or Vesa receiving clear funds, but in my submission, for the reasons that I'm going to set out, it can't be as prescriptive as that because of 3.7, which contemplates a reorganisation of the corporate structure. And so if another company or companies in fact was receiving the money, they would still, of course, be obliged to transfer that money to JOP or his heirs. And his heirs, that is dealt with at 3.6, because the obligation is transferable on JOP's death to his son, COP, or to his grandchildren. Now, 3.7 is particularly important for the purposes of this appeal. It's my ground 4, just solely dealing with 3.7, but it goes wider than that and to the whole commerciality of this arrangement. So no amounts shall be, it allows for effectively a reorganization of the Valderrama companies. And so no amount shall be payable in the event that the purchaser reorganizes the purchaser group so that any real estate asset is transferred within the purchaser group or to any company in any way connected or associated to the purchaser. Pausing there, if, however, following any such reorganization, any real estate asset is subsequently, and here transferred is used rather than sold, to a third-party buyer, the provisions of this clause shall apply, and JOP, or any of his assignees as the case may be, shall be entitled to any amounts payable in accordance with this clause 3.7. Then it goes on to say, for the purposes of this clause, we'll query whether that is a reference to the whole of 3 or 3.7. In some respects, I say that that doesn't necessarily matter quite as much as perhaps the judge at trial gave it. So for the purposes of this clause, transfers of any real estate asset shall include any asset transfers as well as any share transfers of the company, there's a typographical error, owning any such real estate asset. So it creates a situation whereby even on the judges, the learned judge's interpretation of 3.7, I say that if there is a reorganization, such as Valser and Vesser drop out of the picture and Soto owns the land directly, if the shares in Soto are then sold, that would trigger the profit share. And to use a second example, if Valser and Vesser introduced new subsidiary companies, Malsa, Mesa, that were below Valser and Vesser and the land holding, again, there would be a recovery if the shares are sold. And what I say, and what the appellant's core argument is that it would be an absurdity if the respondent could escape liability through either incorporating a new intermediary company between Valser and Vesser and the land, or through removing Valser and Vesser or some other corporate restructuring. We say that even if the judge was right, it cannot have been the party's objective intention that upon a corporate reorganization, a share sale would trigger the profit share, but that JOP is left in an inferior position if there is no reorganization. And in that scenario, upon the judge's reasoning, each individual plot of land, whether it's the golf course itself or the plots that surround the golf course, would actually have to be sold, because unless that takes place, any sale of Valser or Vesser or Soto would actually lead to JOP and now COP recovering nothing. We see also, finally, in dealing with this section, at 3.8, JOP shall be punctually notified in writing of any real estate assets transfer, and he shall be duly informed of the details of each specific transaction. So again, there we see this use of the word transfer rather than the word sale. The two seem to be, as I say, being used interchangeably. Can I now turn to clause 4?
Are you going to, at some point, come back to the sort of errors in clause 3.7 in terms of the cross-references to other clauses? Or
of course, I mean, this is me just really introducing the point, and I will, of course, I'm going to actually deal with 3.7 as a specific head of, in terms of a specific submission, my lord. But which point?
Well, it was just, I mean, just reading it on its face. I mean,
yes.
I looking at the second sentence. If, however, following any such reorganisation, so the first sentence you say is designed to ensure that there isn't a, as it were, an inadvertent obligation. There's no obligation to pay anything to
if they just reorganise.
JP if they internally reorganise.
That's right.
But if, however, following any such reorganisation, any real estate asset is subsequently transferred to a third-party buyer, the provisions of this clause shall apply, and JOP or any of the assignees shall be entitled to any amounts payable in accordance with this clause 3.7. There are no amounts payable in accordance with this clause 3.7. It must be a cross-reference to 3.2.
Absolutely.
Or this clause 3.
Yes.
So that's one error, I think.
Yes.
And then you say, for the purposes of this clause, and do you mean for the purposes of the preceding sentence, or do you mean, or should it so should it have said for the purposes of this clause 3.7, transfer shall include, or do you say that it means for the purposes of this entire clause 3?
We say it says the entire clause 3, and the reason we say that, and rather, this is a point that I have referred to in my skeleton, but we say it's the whole of clause 3, and one can look at the distinction here, because one looks at 4.6, which has a similar clause in relation to the trademarks, my lord, and there's an express reference to 4.6. Now, how the judge dealt with that, the judge said, well, this must be a mistake, and I take the view that it must have meant 3.7. But what we say is that one can't do that, because one can't adopt a literalist approach to one part of clause 3 and then not effectively abandon that when it comes to 3.7 and start really almost entering into the territory of rectifying the agreement.
Because just to understand it on the facts, if the last sentence of 3.7 was limited to 3.7,
yes,
i.e. a sale to a third party following an internal reorganisation,
yes,
that hasn't happened, has it?
No, that's right.
So if this meant for the purposes of this clause 3.7, you would lose, just to be clear.
Sorry, my lord, I didn't catch.
If in the last sentence of 3.7 it meant for the purposes of this clause 3.7, you would lose.
Well, you're saying if factually it actually hadn't actually occurred.
Well, there was no internal reorganisation following a sale. So if what this clause is trying to deal with was limited to a fancy internal reorganisation then a sale,
that's right.
You would lose, because on the facts that hasn't happened, therefore it wouldn't be triggered.
Yes.
That's why you say this has to mean.
Well, I say firstly it has to mean that it has to apply to everything. But I also say that when looked at what would happen in the scenario of a reorganisation and a share sale, a share transfer triggering a profit share, that has to be looked at in clear distinction with what the judge has actually found, which is that upon the sale of Soto with no reorganisation, that my client recovers nothing.
Yeah, that's a different point, because you're saying that if the parties provided that you couldn't avoid paying a profit share by an internal reorganisation followed by the sale of shares of a company holding a real estate asset.
Yes.
You say it would be absurd if they didn't mean that, when in 3.2 they just talked about real estate sales.
That's precisely what.
Right, but that so you'd say you'd have to join those extra dots.
Yes.
Yeah, but it's not a triggering of 3.7.
No.
This case is not about.
No, it's not about. No, that's right. No, absolutely, my lord.
Okay,
What we
right.
say is we recover under 3.2.
Yeah.
Yeah. No, but one has to look at 3.7 because it assists the court in an understanding of the whole of Clause 3 and the mechanism and what the drafter and what those parties who entered into the agreement must have intended.
It's slightly odd, though, isn't it? If the drafter is savvy enough to make these provisions in 3.7 and didn't make them in 3.2, you nevertheless said he's what, or the objective bystander would think that the drafters just missed.
Yes, I mean it's not a very good agreement, and there are a number of errors in here. One doesn't know why, but and which is why we're here. I mean, ultimately, because it's a agreement littered with ambiguities and confusions, and a lot of the terms aren't defined, and so one is left having to work through this process of interpretation.
And you would say, bottom line, in effect, of that the whole of 3 must be construed together.
Yes.
And in context, and that 3.2 must be construed in the light of 3.7.
Yes.
Whether or not 3.7 relates to the whole of 3.
Yes.
So 2 separate points.
There are 2.
Does it relate to the whole of 3
Yes.
if you construe 3.7 on its own? And in any event, if you construe 3.2, you need to construe it in the light of 3.7. So I think you're going this far.
Yes.
And therefore, if you did that, you would understand 3.2 to cover more than
Yes.
ground.
My lady
land.
has my point absolutely precisely.
So there are
that it
2
is-
elements.
There are 2 elements to it. That is absolutely correct.
You didn't rather skate over 3.3, which is the mechanism for
Yes.
working out the net profit.
Yes.
And that is drafted purely in terms of what one might call a standard real estate sale.
Yes.
So how do you deal with
Let me-
that? Because effectively the agreement needs to be rewritten
Yes.
to have a provision for working out net profit in the case of a sale of shares as opposed to a sale of real estate.
Can I say a number of things? Because, of course, these matters were all raised by, particularly by Mr. Knox, before the deputy judge. Firstly, the judge found no difficulty in the end of actually carrying out that
Well,
exercise.
is that fair? He said it is rather difficult at various points. Isn't
Well,
he? So
he did it, and the judgment sets out those deductions. And secondly, my lord, the parties were aware that no other assets were held by Valsa, Vessa or Soto save for the land. So this wasn't a case of, as Mr. Knox suggested, that there would be a great difficulty in carrying out this exercise, but the parties knew that these were just corporate holdings and ways of actually holding the land for different reasons that I've already given you, both the tax advantages and the avoidance of litigation with the members. And so they were able to hold it in that way and make the deductions very easily upon a sale. And in any
did
event...
the judge make a finding that no other assets
Yes.
were held apart
Yes.
from one?
Yeah,
Perhaps you
that
could
was
give-
accepted.
Give
There
us a
were.
reference to that.
Yeah. I'll
'Cause I thought there was rent coming in at some point, which must have gone into a bank account.
my learned junior says it's into an escrow account now.
But we're to assume that a professionally drafted agreement has, in effect, elided the corporate vehicle and the real estate.
Yes. And can I give also an answer to Sir Christopher Floyd's a third point to your question, and a third answer is 3.7, because 3.7 clearly anticipates a share transfer triggering the profit share, and yet 3.7 doesn't say in the event of a share transfer you have to work out the net profit in a different way to clause 3.3. So the reasonable reader would assume that the way one does that is to go back to 3.3. So the
Suitably adapted for the different
yes,
subject
which is
matter of the
suitably adapted, which is what the judge actually did and was able to carry out that exercise.
I mean, what it boils down to, you say, look, if they envisage a trigger on a sale of shares of companies owning real estate assets in the circumstance set out in 3.7, where there's been an internal reorganisation first,
Yes.
surely they must have intended the same where there isn't a reorganisation first.
Yes.
To which one answer might be, but given that they clearly contemplated that, why didn't they say so in 3.2, which you would have us read to include that?
Well, they didn't say many things here, and I mean the problem is that were one to adopt that literalist approach and say, well, they didn't adopt that does leave the parties, either JOP or any heirs, in a rather strange position where the respondent could take a very easy course. Actually, this is a neat sort of segue into my ground one, into a very neat way of actually effectively cutting my client out of any profit share.
You'd say it's absurd to think that the parties intended that there would be a profit share payable if the purchaser group conducted an internal reorganisation before selling, but were able to say, well, for goodness sake, as long as you don't conduct an internal reorganisation first, and then sell your free and clear.
And one would be in the position. That's right, my lord. I mean, one would be in the position where it would be then in JOP or COP's interest to encourage some form of reorganisation and hoping that the reorganisation took place, and then MGI would have been in a position to resist any reorganisation, which of course they had control over, because it would be in their interest not to reorganise the corporate structure.
Does it matter that they've gone on to adopt the same structure for trademarks under clause 4? So again, you've got sale of the trademarks, and then a mechanism which is specifically adapted to the sale of trademarks. We've got brand development fees and so on.
Yes.
And then a 4.6, which has got the words in the last sentence, but this time expressly for the purposes of this clause 4.6.
Yes.
But again, on your approach, the objective reader would say it's 4.2 has got to be adapted, and the profit share has got to be triggered in the event of the sale of the shares and holding company.
Well, actually, what you actually have to say is that the reference to 4.6 is a mistake there, because you have to say, no. It should have said for the purposes of this clause 4, or at least for the purposes of the clause 4.1. So, in other words, that is a mistake there. So, what you're actually saying is, so as well as looking at 3.7, you're saying the last sentence, in essence, should be either read as saying for the purposes of this clause 3, or at least you ought to read 3.2 as if it swept up the same concept. I think by process of analysis, you either have to say that is a mistake at the end of 4.6, or alternatively, you have to also read 4.1 as applying if there is a share transfer rather than the sale of the asset transfer.
And I say that yes, a sale has to be given that wider meaning, because otherwise there is again, and the points that have been made from the bench in relation to 3, there is this inconsistency between the situation where there would be a reorganisation and a trigger, and then a share transfer, and that leads to a profit share taking place. But if that doesn't take place, JOP gets nothing.
And you justify this quite substantial violence to the express words drafted professionally on the basis of the absurdity of the outcome.
Well, there's a number of grounds, and in fact, my lady, it leads me on to really my ground 1, which is the commercial unrealistic nature, and I want to turn to some of the what I say about that, and those are set out from paragraph 19 of my skeleton, and starting off with Arnold and Britton. And I've actually set out there, and I can take my lady and my lords to Arnold and Britton in the authority bundle, which is at...
I don't think that will necessarily be necessary
unless
there's something special.
Well, I wondered that, and because I've set out what Lord Newberger says there, and in particular the bottom of page 258, what a reasonable person having all the background knowledge, and that's why I've spent quite some time about the background and that period of time from 2010 to 2012, which would have been available to the parties, would have understood them to be using the language in the contract to mean. And then going over the page, that meaning has to be assessed in the light of the natural and ordinary meaning. I'll come to that in my second ground. Any other relevant provisions of the lease, of course that case was regarding service charges of chalets, the overall purpose of the clause in the lease, the facts and circumstances known or assumed by the parties at the time that the document was executed, and then fifthly, commercial common sense, but disregarding subjective evidence of any party's intentions. Now, in terms of what I say at 20, I say for a number of reasons, in fact I've set out 10, that this leads to a commercially unrealistic and absurd result. The first one is the one that we have just touched upon, which was that the respondent was being afforded an easy way of circumventing the profit share agreement. All it had to do was sell assets at the holding level or at the Valsa Vesa level, and then the respondent could get 100% of the profit.
Sorry, you mean sell shares?
The shares, yes.
Sorry, you said
Rather
sell assets. Sorry, you mean sell the shares in the companies?
The shares, all they would have to do is sell Valsa, sell Vesa, or sell Soto.
Not having done an internal reorganisation.
Not having done
real
an internal
estate or the
exactly
first, right?
Exactly. And there it would free itself from the financial obligations under the profit share agreement. And there I've referred to for that point from Lewis and the interpretation of contracts at 2.63. And the judge, in my respectful submission, was also somewhat confused in terms of the terminology that he was using. And we see this at paragraph 144 of the judgment, page 65 of the core.
It's not just Mr. Knox, it's the judge as well. It's fallen into this happy error.
And we
Sorry,
see...
Just you saying, when you said Lewison, you
Yes.
referred to paragraph what?
So that was paragraph 2.63, and we see that in the authorities one. I'll deal with that first, my lord. That's at the back. Lewison is at... there are two sections of Lewison that have been produced in full. We see that at tab 21 and tab 22. This is at tab 22, paragraph 2.63.
I think it's at 21, actually.
Sorry, 21. 22 is chapter 7. And we see the nature of business common sense. And if we turn over to 665, and the point here is that the principle of that equivalence of obligation is a feature of most contracts, and the avoidance of burdens and conversely of windfalls. And what we say is that this effectively was giving the respondent a windfall that it should not have.
We must also bear in mind, of course, that I think it's Lord Neuberger says that you must take into account that sometimes parties enter into a bargain which is a bad bargain for them.
Well, I don't say that this is that situation. I mean, that's absolutely right, and I'm well aware of that principle, my lady. But this isn't a case where one would say, well, it was just simply a bad bargain, because what I hope that I've already started to highlight is that clear lack of commerciality and absurdity between the various provisions in the contract, and it really as to why would a party enter into an agreement of that nature, which only gives them the profit share upon the reorganisation in terms of a share transfer, but not beforehand. I was at page 65 of the core, and the judge referred there at page 65 to clause 5.1 of the share and purchase agreement. And just the reference there to the seller being the owner of Soto shares and the Campo shares, and indirectly of the Valsa.
So this is a different. This is a sale and purchase agreement.
This is the sale and purchase agreement.
This is subsequent.
This is on the same day. The same day this was entered into as the profit and the profit share agreement.
It says in 144 that it's the 2015 SPA.
Oh, that's the 2015. Yes, so in the 2015, upon the sale, the point that I wish to make is that it says that the seller is the owner of the Soto shares and the Campo shares, and indirectly of the Valsa and the Vesa shares. And we see that also in paragraph 1 even of the judgment, where the judge refers there to this being a dispute relating to the sale of shares in companies holding real estate in Andalusia.
Okay, I mean,
so
I'm struggling to understand how we interpret the 2012 agreement to a statement made subsequently in 2015, which doesn't fit within Lord Neuberger's framework at all. Accurate or inaccurate use of language in 2015. I'm struggling to understand how that's an aid to interpretation. I really am.
Well, let me move on to my second point, my lord, which is that the judge's interpretation meant that profit share agreement held no commercial value for JOP or his heirs. As I say, if that could be easily sidestepped, then JOP may well not have entered into that agreement at all. It was
this is the same point that you've already made, Mr. Blake,
yes,
I think.
That's the point that I was just making.
Isn't it putting it a little bit too high? Because in the event of sales of individual plots for development, you would get a share of the profits calculated on the basis of clause 3.
But that's right. But he gets a share. Remember, the obligation is to find is to use the reasonable endeavours to find any and to sell any and all. So if a individual plot is sold, it recovers a profit share, but not if the whole if the whole of the group is sold. And we know that in my submission that the parties were aware that they couldn't sell all of the land at the level of just transferring the real estate.
No, I was just
because
thinking
they were going to have
no commercial value. It had much more limited.
It had limited
value
commercial
than
value.
if
Yes.
it was triggered on the sale of the whole thing. But sales of individual plots would give him something.
Yes. The judge actually made his own concession here and appears, in my respectful submission, to have struggled somewhat with the issue at trial. And we see that, for example, at paragraph 214. I'm now moving on to my third point at the bottom of 259. Because he actually said at paragraph 214, it may be that some criticism could be made of the commercial consequences of the transaction for JOP. In my respectful submission, an acceptance that his conclusion was uncommercial. And this is important because in my respectful submission, he discarded commercial reality. And
before you go on, I think that's rather an unreasonable way of calibrating the role of the judge, apart from what he says at 214, in the sense that there's no concession. He's actually addressing an issue which is being raised before him, and he's putting that in the context of other things. So I think that's rather unfair to the judge, Mr. Blaker.
I apologise then. But the point that I seek to make, my lady, is that what the judge needed to do was to look at the commercial. He accepts that some criticism could be made of the commercial unreality of the situation. And he needed to go on to the next step, which was to, as Mr. Justice Lewison, as he then was in Norwich Union Life, and I will turn to this authority, he said, now that I set the principle out in writing, is that commercial common sense is not merely a cross-check, it's an essential part of the process of interpretation. And so what I say is that there are two steps there. Firstly, the need to adopt commercial common sense as part of the interpretive process. And then when the judge has carried out that exercise, to then go back and have this commercial common sense sort of cross-check. And we see that. My lady, are you looking for the, because I can take you to that authority of Norwich Union in bundle one of the authorities. Bundle two. This was a landlord and tenant break clause and consent to assign case, and we see that's at page 419. And what we see at page 40, paragraph 44 of the judgment. Let's see if you can read that. It said the principles set out in paragraph 44.
But then, in Rainy Sky and Cookman, one has the situation in which, if you just look at the head note, that one looks at the natural meaning of the words, but if they produce so extreme, this is the top of page 435, the bundle, a result so extreme as to suggest that it was unintended, the court had to give effect to that meaning. And then look at relevant surrounding circumstances, and if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense. So there are two different things here. There is this so extreme it can't have been what is intended? But then business common sense comes in at the end if there are two opposing interpretations. And I think that's the way that people approach this matter. Would you say, Mr. Blaker?
Yes, I think that's, and I say that on both approaches, they would lead to a reversal of this of the result in the trial of that interpretation, because however one adopts that approach of the judge, both, I mean, there's clearly in my submission, one can't just simply only look at the words and just and effectively ignore A, the factual matrix, or B, the commercial common sense. Both are essential parts of aiding interpretation, and in particular in this case, clause 3. So my third point.
So you say, is this right? You say that business common sense or commercial common sense is not limited to choosing between two available meanings on the language, which I think it plainly is. I mean, I think Rainy Sky says where you've got two possible meanings of language, business common sense allows you to choose the one which makes the most commercial common sense.
And I don't disagree with that.
Do you, though, say that where the language looked at on its face is not ambiguous, business common sense allows you to adopt a different interpretation short of absurdity? So I thought that the way it was put is that you can't use business common sense to overcome language which is plain on its face, unless actually the result is not in accordance with business common sense, but just absurd.
I say two things in relation to this particular case. One is that and I don't disagree with my Lord's analysis of those points at all, but I say that again, in those scenarios, here, when one adopts business common sense and how the parties on an objective basis entering into this agreement, they would have considered that a sale of Soto would trigger the profit share. And secondly, I do say that actually, for the reasons that I've already given in relation to that interrelationship between 3.7 and the rest of the other clauses, we do start to fall into the territory of absurdity. That actually the reorganization creates a preferable situation for my client than one where there is no reorganization. And so, as I say, I don't disagree with that legal analysis, but its application to the facts of this case, I say, assists my client on both those principles. And we see at my number 4 that the respondent was obliged under 3.1 to endeavour to find third-party buyers for any and all of the real estate assets. And everyone knew that the jewel in the crown and the prize asset was the golf course itself. The parties thus intended for the respondent to market and sell the entirety of the assets, including the golf course.
Well, that was one of the possibilities, but not. I mean, you could come. It doesn't. It says any and all.
Yes.
It means you could perfectly well fulfil that obligation in relation to the individual plots of land, which were real estate in the narrow sense.
Yes.
I mean, you're effectively trying to write out the words any and.
No.
Just say it has to be all. I mean, as I understand your argument in this respect, it's putting a lot of weight on the word all, because what you're effectively saying is, because it says you have to use reasonable endeavours to find a buyer for all includes the golf course, since everybody knew the golf course couldn't be sold separately, ergo, you could only do this if you could sell the shares in Soto, therefore that's what the parties must have envisaged, therefore they must have envisaged the profit share to apply to it.
That's right. But what I do say, I'm not trying to rewrite or remove words, because it says, firstly, it says any and all. So they were under, I mean, again, that's another of the difficulties with the way the PSA has been drafted. But again, in my submission, they, if they decide to sell the whole of the assets, including the golf course, in my submission, that clearly triggers the profit share. In similarly, if one developed one plot of land, if it had just said, and been more specific and said, develop a particular plot and they build some villa on it, and sell that, then of course they split that profit. But here, if they've sold everything, that is going to trigger the profit share agreement.
Bit more indirect than that, isn't it? If they sell everything, they can't do it by direct asset sale. They have to, you say, they must have realised they would have to sell
Yes.
the shares in the company instead.
That's right. They knew because it already been flagged up so heavily that a sale of all of the assets couldn't be done at that lowest level in terms of a real estate transfer of in terms of how land is sold in Spanish law. And we see this, that even the judge at paragraph 198 has a difficulty in the middle of that paragraph. He says that explanation is not entirely satisfactory in that the obligation under 3.1 is wider and extends to any and all real estate assets, and so includes the golf course, for which there was no real prospect of a separate sale. He then goes on to not follow the approach that I was urging the court to adopt. But the judge, and this really again comes on to some of those difficulties. Firstly, the parties knew, now at my paragraph 5, the parties knew that the RCV had those preemption rights, which made that a separate sale to a third party virtually impossible. And that's also, and again, I've set out there where that is set out in terms of the judgment, and the judge was set out that the members were concerned that the sale of Soto would override their preemption rights, and there's they issue. We can see the difficulties and why very shortly after the profit share is entered into, and again I hesitate going into anything that's after the profit share, but again it just highlights what must have been in the knowledge of the parties, that firstly they stop paying rent for the golf course to Valsa in the November, 1 month after the transfer, and we see that in the judgment at 113. And secondly, they issue what's called in Spain a querela, a private prosecution.
Well, you say you hesitate, but you didn't hesitate very long. I mean, why are these things relevant?
Because it indicates, because they're so shortly after the profit share agreement, that they are an aid to understanding what the parties would have been aware of.
Why?
In terms of the difficulties.
Well, how did the parties to this agreement know what the golf club was going to do a month afterwards? Where's the evidence?
Well, I've already shown you, my lord, the due diligence, of course, which had flagged up these ideas.
The due diligence is due diligence. We see the document.
Yes.
But the due diligence didn't say the members are going to issue a querela or anything like it. So, I mean, I don't understand why these specific facts you're now pointing out go beyond what is relevant and go admissibly beyond what's in the due diligence.
The due diligence did actually flag up, my lord, the prospect of litigation with the members.
Right, so I understand why you say that might have formed part of the matrix, that predated it, but why does it help us to look at what happened afterwards.
Well, as I say, it's only if it had been anything other than such a short period of time afterwards, I wouldn't take that point. It's only that these happen in the November and the December, a very short period of time after they enter into the agreement, which in my submission highlights the fact that there is this background of tension even leading up to the PSA. The parties again knew that RCV held those 6% of the shares, and the judge noted at paragraph 45 of the judgment, if I can take you to that, 45 and 46, that the only commercially feasible way was to sell all of the real estate assets, was to find a buyer for Soto. 45 and 46. And as I've already said, there was no evidence that they ever sought to find purchasers for individual plots themselves. And at paragraph 100 and
Okay, so, sorry, what's your point on 45? Where does the judge find that MGI was notified of what's set out in 45, and if so, where?
those are the points that I did draw my Lord's attention to earlier on this morning as to where he accepted that they had already, that they were aware of the due diligence and it was attributed to MGI.
But the due diligence, yes.
And that also included those legal opinions.
No, 45, not 46. You asked us to look at 45.
Yes, at 45 and 46. Well, I say that that 46 was also 45 was also referred to in the DLA due diligence, because there was the reference to the sale of Soto overriding their preemptive rights, and that was also set out in that document at 220 in the supplemental bundle, which was signed by Mr. Moxon in the September of 2012.
May I say, Mr. Blake, that I'm becoming rather concerned about time, because this is just ground one, so I assume that you're near the end.
Of my, yes. So if I can try and move with some greater speed, then at paragraph 8 and 9 of page 261, I say that the respondent never satisfactorily, the judge observed that the respondent never satisfactorily explained why, if there wasn't an intention to sell the golf course, why they entered into that precise obligation. In addition, there were practical difficulties which I alluded to at the beginning. In paragraph 9, it was put to FOP that the respondent accepted that the golf course needed other plots of land that were owned by Valsa and Vesta in order to host the tournament.
I'm very sorry to intervene. I put to Felipe that there was one plot that would be difficult. One plot next to the land, because that's where the cameramen put their cameras up. One plot would be difficult to sell separately from the golf course. It certainly was not put that any of the other plots would be difficult to sell.
Notwithstanding even putting it on the narrow basis that Mr. Knox suggests, the fact is that when one's dealing with a golf course which hosts tournaments and needs to have land around it that was going to be able to be used for the purposes of the media and tournaments, it wasn't something that you were going to be able to split up easily. In terms of I've dealt with the point at number 10 already. At 21, I say that the construction of one part of a contract must be in harmony with the contract as a whole. And
that was when I made those 2 points that
Yes.
I thought you were making.
yes,
It's the second one. You have
That's-
to read it in context as a whole. And if you do that, you say you come to a different
that's
conclusion.
right. That's right, my lady. And then over the page, as I say, in 22, essentially the key asset was the golf course itself.
This is the same point again.
And it's the same point there. Now, what I do say, again, and it does need to be dealt with at 24, though, is the that's the perilous nature of JOP's finances. But I say that reasoning is flawed. Firstly, I say it's a non sequitur, that the interpretation means that it could be easily circumvented. And again, I've already dealt with that point, and he may well have not signed it. There would have been no reason for JOP to have entered into that transaction with little or even no advantage to him or subsequent generations. And then in my second point there, I say that he impermissibly strayed into subjective intentions by looking at what...
But isn't that looking at the context as it arose at the time of the agreement, and that one of those was that JOP needed to sell?
Well,
I'm just
yeah,
being the devil's advocate.
No, I appreciate that, my lady, but I think the point there is that there wasn't, of course, JOP had died quite some time ago. There wasn't any particular evidence before the court of his precise financial situation, and so that's why I say it's impermissibly straying. Now, my second reason is the natural and ordinary meaning. We come from the commerciality to the natural and ordinary meaning, and I say there that the natural and ordinary meaning is not a strict or pedantic or grammatical understanding of a lawyer. What one has to look at is what ordinary business people would understand a contract to mean, and I've set out Weardale Cole, what Lord Isha, Master of the Rolls, said in paragraph 27. Again, I can take you to any of these authorities, but I've set the principle out. And similarly in Manai, a very well-known case, the standard of the reasonable commercial person is hostile to technical interpretations and undue emphasis on niceties of language.
Is that where the agreement, obviously Manai may be different, but is that, no it isn't actually when I think about it, is that where the agreement or the instrument you're construing is written by a non-lawyer? Can I just get my bearings here? I mean, we're interpreting an agreement written by a lawyer or by lawyers. Are those quotes taken from cases which interpret documents written by non-lawyers, business people?
I accept that. I mean, in Manai
was a
dealing with notices.
A landlord and tenant's notice.
Yeah, absolutely. But what I say is, yes, of course, it's a sliding scale. I mean, if one has got a document that's been drafted by lawyers, it may be treated in a different way, but not if there's the level of ambiguity. It doesn't mean that one can just simply not approach it as to how reasonable.
But I thought there were a number of recent authorities, including some from the Supreme Court, very recently, which say it is important when you're interpreting a document to understand who wrote it and apply.
And I appreciate that, but in this case, the fact that there was a lawyers writing it, still doesn't overcome the fact that one should just adopt a literalist approach to the words of clause 3.
It's not so much literalist. It's just that you don't readily, you might readily assume that non-lawyers express themselves broadly and often inaccurately. You don't make the same assumption about the way that lawyers do it. They might do, but you don't assume that they will from the start.
But what I say is,
Wood and Capital.
yes, it's Wood and Capital. And I will deal with that. in a moment. So what we see at paragraph 30 is that the judge focused on the words owned by Valsa and Vessa. But what I say is that if one asked a business person, rather than a lawyer, in the shoes of Zagaleta, what they'd actually purchased in 2015, the natural and ordinary response would be the golf course, the land, and the trademarks. It wouldn't
We're not interested in what Zagaleta might have thought in 2015 at all, are we?
No, but similarly, one would ask if MGI was asked the question in 2012.
Yes.
They would answer also in exactly the same way. In my submission, it's hard to believe that any objective bystander would describe the transaction as just being of shares in a Swiss holding company, which is the technical method of acquisition. And similarly, as I say, if someone, a passerby, went to Valderrama to play golf in 2013 and asked who owns this, they would not, one presumes, be given a technical answer in terms of various holding companies. And this is important because at paragraph 32 of the judgment...
So you're saying actually that the natural ordinary meaning is always that one should look straight through a company to its assets. That can't be right, Mr. Blake, can it?
I don't say that, my lady.
Good.
I say that in this particular factual scenario of this case, with the particular holdings of the land and what the parties understood in terms of the structure of the holding, here they did. One would look to Valsa, Vessa, and then the Swiss company Soto. And we see this in paragraph 32 of the... I have the wrong paragraph. I'll have to find the paragraph reference, but the judge himself refers to the...
Paragraph 254, but I think you've made it
254.
some time ago.
Thank you, Maria. Yes. On page 254, at page 101, the judge himself refers to the real estate assets being acquired by MGI through the purchase of the Soto shares. And so in my respectful submission, the acquisition of the asset is being described as an acquisition of a real estate asset, and yet the sale in 2015 to Zagaleta is not. And it must be that the parties' reasonable contemplation was that the parties would buy and sell the real estate assets in exactly the same way. What I say at 33 are some of the answers that I've already touched upon, in particular with Sir Christopher Floyd's questions, which is how to have carried out the exercise under 3.3. And what I've set those out at 33A to E, that each of those deductions under 3.3 could be carried out, and indeed were carried out quite happily by the judge. And the judge, as I say at 34, found a perfectly workable formula when calculating net profit. And we see that in detail at paragraphs 250 to 263. So it was perfectly possible and natural to apply 3.3 to a sale of either Soto, or Valsa, or Vessa. no adjustment actually needed to be made because Soto, Valser and Vesser only owned the real estate and the trademarks. And so Soto's value was actually the same as the value of the land and the trademarks. And the judge appeared to accept that at paragraph 173 of his judgment. And again, I leave you to look at paragraph 173, please. So one reaches the conclusion, my lady, is that the appellant's construction is the natural and ordinary meaning of the PSA. And indeed, it's the only construction which gives a natural and ordinary meaning to the phrase any and all. Because upon the judge's construction, the all is effectively ignored. And
Yes.
the judge, in my submission, fell into error there for the reasons that I've set out at 36, at page 266. At paragraph 199 of the judgment, he held that MGI's plan was to develop and sell plots of land, but the due diligence showed that the parties expressly contemplated the sale of all the assets, and indeed those are the words used in the agreement itself.
So is this an attack on his finding of fact? Looks like it to me, Mr. Blaker.
Well, he's not really made what I say is, well, firstly, these are questions of mixed fact and law anyway, and that it's not actually an express finding that he's made in terms of a factual finding there.
Well, I was just looking at paragraph 36, one of your skeleton, where you say at 199 the judge held, etc. But I don't want to quibble. I just let's
no, I
go
understand
on.
the point, my lady. What I say at paragraph 2 was that whatever MGI's plan was at that time of the profit share agreement, on a subjective basis, it has to yield to the objective approach of deducing the parties' intentions from the actual language used. And that language was to find buyers for any and all the assets. And it's unhelpful for effectively to say that the golf course wasn't going to be sold during the life of a potential fund that actually never got set up by MGI, because the fact is that, objectively speaking, the parties did intend for the golf course to be marketed and to be sold. And that profit share agreement wasn't time limited. So the evidence, and again, I slightly hesitate to go into any evidence, but that this was a time limited fund that would eventually be sold. And my point is that the profit share agreement had no time limit on it. If Soto, if the golf course, if all the assets were sold in 10 years' time, that would still trigger the profit share obligation.
So just going back to paragraph 100, the judge's finding in paragraph 199 of the judgment.
199?
199.
Yes, ma'am.
His finding is that at the time that it entered into the 2012 SPA, MGI's plan, as evidenced by the draft prospectus, similar to the draft prospectus produced by TSG before it, was to establish a fund that would generate profits, at least in part through the development and sale of properties on the land owned by Valser and Vesser. That's part of the matrix, isn't it, of fact, against which this agreement falls to be interpreted.
Well, so is the fact that...
Yeah, but answer the question I put to you before you give me another one. I mean, is it or is it not part of the factual matrix?
It is one part of the factual matrix, but there are many other parts of the factual matrix, my lord, such as the fact that the judge found that that never actually happened and that the plan fell away. He says later on there, the plan fell away quickly, and MGI was
Well,
forced to change
falling
that.
away of the plan, I think, is probably not part of the factual matrix because that happened after the agreement we're looking at.
Well, with respect, my lord, I say no, because the parties firstly have the words any and all, and so the idea was to sell all the assets, or certainly have the ability to sell all the assets, and secondly, that was already flagged up in the due diligence and all the information that they'd already got in advance of the profit share agreement, that there was this ability to be able to sell everything, including the golf course. So it isn't quite as I mean, I do say, of course, that is a strand of factual matrix, but only one element. And what I also say, and the judge found, there was no actual evidence produced that the fund never got set up, that they were even going to set it up, and that they actually ever tried to market individual plots.
This goes to two issues, which I think we've already asked you. Early on, Christopher Floyd picked you up when you suggested that there would be no benefit to your clients of this agreement if it was interpreted in the way the judge interpreted it. And I think, as I would understand it, you accepted that at least there would be some benefit to your client if there was a series of sales of plots of land, because the agreement would be triggered in relation to the sale of each plot of land, as and when the plots of land were sold, as indeed MGI were at the time contemplating doing.
But that benefit would be extremely limited.
Well, it would be a benefit as opposed to no benefit.
It would be
some benefit.
But
you say, I think your argument on interpretation is essentially that it's though absurd to suggest that what the parties envisaged was that if there were sales of individual plots of land, money would be paid, indeed all the way right up until everything was sold. There would be profit share. But if in fact the entirety was disposed of under the sale of the Soto shares, so not in fact disposed of at all, but the Soto shares are disposed of, which carries with it the control of everything, nothing would be paid.
that's right.
That's one absurdity argument. The other absurdity argument is if there was an internal reorganisation followed by the sale of the shares in a real estate asset, an individual real estate asset, that triggers, but not if there's no internal reorganisation and the sale of...
No, my lord has my point.
Right. So there are two sort of points. One deals with the question of benefit.
Yes.
And the other deals with a number of factual scenarios in which you say, I think you have to say that there's just an absurd conclusion, it's an absurd result.
Yes.
If you don't interpret the agreement the way you say.
Yes.
I mean, have I
No, I
encapsulated it?
think that yes. Yeah, that's absolutely
Right.
the case, my lord. Yes. But I also say that, and it comes on to my third reason, is that the judge failed to give sufficient weight to some key facts in terms of the factual matrix, in terms of interpreting the PSA. And what I say there, firstly, as a background, you'll see at paragraphs 38 and 39 that I've referred to the unwritten rule of judgments being handed down within 3 months, and this was handed down nearly 6 months after the trial. Now, I don't say that that is, in essence itself, a good ground for overturning the judgment, but what I do say at 39 is where I've cited NatWest Markets, is that any advantage enjoyed by the trial judge diminishes in importance as a consequence of the lengthy delay. And I say that the delay in this case justifies closer scrutiny of how the judge actually handled some of the evidential, factual matrix questions here.
I don't understand where that's going, in the sense that are you then saying again that this is a challenge to the facts as found or not?
what I'm saying is that a number of the factors that I've set out in paragraph 40 weren't matters that appear to even feature in the judgment or the reasoning of the judge.
Okay,
And
we've
so
got those set out at paragraph 40.
Yeah, sorry, my lady. I was just going to say it's difficult for me to answer directly in the sense that it's not a factual challenge to, well, the judge has reached this conclusion and we disagree with that. These matters that I say were relevant don't even feature at all. So we see, for example, at 40 subparagraph 1, Mr. Moxon said the business plan was in the next 5 years after the 2012 SBA to transfer it into another fund, sell it on to a private sale, sell the group for another group, so there would eventually be a sale, of course. And what I say is that that indicates the very clear commercial purpose of this. And I can take you to the actual, there's a wider...
just to be clear, are you saying this was a commercial purpose of MGI,
Yes.
which had been shared with the other parties to the 2012 agreement, or just was this an internal subjective intent of MGI?
Well, I say it has to be the former, because there would have been lengthy discussions leading up to. But
I mean, unless this is part of Matrix known to both parties, and if I dared to be sort of critical or otherwise of Lord Newberger's little précis of the principles, you have to read, just to be clear,
yes.
When he says known to the parties, he means known to both parties.
Yes,
I think that's, everybody understands that. So obviously it goes without saying perhaps. But if Mr. Moxon's evidence is just as to the business plan of MGI, I don't really understand that it was relevant to Matrix, and I frankly wouldn't have understood what the judge would have been doing if he'd have been referring to it anyway.
Well, I do say, for example, at number 3, that he's aware of the B shareholder rights in Valsa, which I've already dealt with, and again, I don't. That didn't.
But the fact that Mr. Moxon was aware of it, I mean, why is that so relevant?
Because that is something that both parties would have been aware of.
What? That there were B.
Yes, and that the only way.
No, the relevance is that there were B shareholder rights in Valsa, which the judge has repeatedly referred
yes.
to.
And what
the fact
I've
that
said,
Mr. Moxon was aware of it is neither here nor there.
Well, what I've also said at number 4 is that he was aware that the only way around it of exercising their rights was the sale in Sota. I mean, I don't want to repeat and labour the point. It's already.
The judge made a finding to that effect, more or less, isn't it?
Well, more or less, although that doesn't.
And it's based on the due diligence that he referred to.
Yes.
So I think
Yes.
we can go on.
Yes. So what I also say is that at paragraph 7, again, what I say was a key concession made by Mr. Moxon, again, didn't feature at all in the judgment. That when asked about the hypothetical question, if Soto is sold, there was an acceptance there that a profit, if he said it sold for £50 million, having been purchased for 40, there would be a profit share of the £10 million profit. And again, that.
So was that evidence as to what Mr. Moxon actually understood the agreement to mean, or that was the agreement that he thought he was entering into?
Well, I say that's what he clearly understood. That was the objective understanding of the.
So why is there no claim for rectification of the agreement?
Well, I say it didn't need to be rectification, because one could deal with this through the purposes of the principles of interpretation, my lord. We didn't need to.
But on interpretation, this sort of evidence is inadmissible, and it would be admissible and relevant, but for a rectification claim you aren't making.
Well, those are the hazards of litigation in terms of.
Well, it's not so much the hazard of litigation. I'm just trying to understand why you say that this evidence is A, admissible on a question of interpretation, and B, you criticise the judge for not taking it into account. At the moment, I don't understand it to be admissible, so why is the judge to be criticised for not taking it into account?
Well,
still,
I say that...
Still less for allegedly not having or forgotten about it because it took him 6 months to produce the judgment, which is what this is actually said to all hinge on.
Well, what I say there, anyway, is that it goes to the heart of the objective understanding of the parties before they entered into this agreement, and that back in 2012.
But so you say the objective understanding of the parties. This is all to do with the subjective state of mind of Mr. Moxon.
I understand that, but that upon a sale of Soto, any objective, for the reasons I've already given, in terms of anyone who came along and said, you know, if you sell the holding company, you're going to have to pay a profit share. I say that that is something that the objective reader of the agreement would understand one had to do, and that it's only for that point, my lord. I'm well aware that one can't take into account things that happened after the profit share agreement was entered into.
And that's paragraph 8.
Yes. If I turn to my fourth...
Can I just ask, I mean, I'd understood one of the points you were running was that this was the type of case which is referred to in some of the Supreme Court authorities where the parties have come across a state of affairs that they didn't contemplate at the date that they entered into the agreement, namely a sale of the holding companies. The points you've just been making seem to me to contradict that, because these are points which you're saying were obvious at the time they entered into.
I mean, that's my fifth reason, my lord, and I'm just going to... I've got number 4 and number 5.
Your fifth reason is in the alternative, is it?
That is in the alternative.
Yes, I see.
The fourth reason...
And I must encourage you to move on, absolutely.
Yes, thank you, my lady. This really, and we've already touched upon a great deal of this, so I'll be able to move through this quickly, is 3.7. And the first point there, that 3.7 is not just merely a drafting error, and there has to be consistency between those particular clauses. There was no evidence at trial, and now on to my paragraph 46, there was no evidence at trial that it was a drafting error, no evidential basis for that.
But you wouldn't expect that, would you? You just look at the agreement
Yes.
and look at it as a whole. You're not seeking out what mistakes or what might have passed between the lawyers at the time. That's not what you're up to. Anyhow, go on.
Yes. At paragraph 2, there's no evidence that the parties intended for consistency amongst the 3 clauses.
That would be inadmissible, wouldn't it? Party's intention.
Well, yes. In paragraph 3, the judge there at paragraph 207 said that the word transfers doesn't carry the same meaning as sale. Now, I spent some time earlier on about this meaning of sale and transfers and sold in clause 3.2. But for the reasons that I've set out before, it's hard to see how transfers and sale can be so different as the judge suggests, because the sale of an asset necessarily involves the transfer of the asset itself. And one sees throughout clause 3 the interaction or the use of the word sale and then the use of the word more commonly in that clause is the word transfer. In paragraph 208 in the core, in the judgment, the judge goes on to reach a conclusion on 3.7, and he said that the parties intended to prevent MGI from circumventing the provisions of clause 3, and in particular the provisions of 3.2, by parceling real estate assets into companies and selling the shares in those companies to third-party buyers without triggering the obligations in 3.2. Now, what I say is that once that principle is accepted, for the reasons that I've already set out, my lady, it's difficult to see how the court could have intended the respondent to circumvent the profit share by selling the assets in the existing parcel of companies, namely SOTO, without it being a trigger of 3.2. And I've referred then in the following paragraph to a Supreme Court, a fairly recent Supreme Court authority of Barnardo's and Buckinghamshire.
And these are the points that you've already made.
And they're the
49.
Yes.
That they can't have intended there to be a loophole.
Yes.
I think we understand.
And then we move on to my final point, which is that even if the sale of SOTO was an unforeseen event, the parties would have intended the profit share to apply to it. And what I say there at paragraph 50 is that it falls within what very much within the principles within Arnold, and I've referred there to paragraph 22 and also paragraph 71 of Arnold and Britain. And again, I can take my lady, my lords, to that. And one sees this at paragraph 22, page 14 of the authorities bundle. That's Lord Newburger's sixth point. In some cases, an event subsequently occurs which was plainly not intended or contemplated by the parties, judging from the language of their contract. In such a case, if it's clear what the parties would have intended, the court will give effect to that intention. And then we see and then we also see at paragraph 71 in Lord Hodges' judgment reference, and again I'll just leave you to read, I'm not going to read out the whole of paragraph 71, but there's again the reference to the inference of intention.
Yes, they infer the intention of the parties at the time of the agreement from the contracts as a whole, etc.
Yes, my lady. Now, what I say is that it was wrong for the judge to hold that the parties could not have intended a sale of SOTO because the drafting, as he said, the drafting clause 3.2 simply doesn't accommodate such a scenario, because we know already that 3.7 does anticipate that precise example or event occurring. And so what I say at 52 is that the judge ought to have considered what the parties' objective intentions should be inferred to be if the sale of SOTO was an unforeseen event. And what I say there is that there were effectively two options. Option number one is that the parties were inferred to have intended that the respondent could keep all the profits and share none. All the parties were inferred to have intended that the respondent would share 9% with JOP. And I say for four clear reasons, the latter is the preferable approach. Firstly, the very existence of a profit share agreement itself. The commercial purpose was to share profits. Secondly, no good reason for the parties to consider that the respondent in that scenario should keep all of the profits. Thirdly, the phrase any and all could only denote an intention for the sale of SOTO to be subject to profit sharing in the surrounding circumstances. And finally, 3.7, which shows that the parties intended to close any loophole that would permit the respondent to circumvent the profit share agreement. Similarly, I say, and I've already again touched upon this, was the difficulty the judge found in terms of the words of payment being received by Valser and Vesser. I'm now on my paragraph 55. But again, the judge failed to consider what would actually happen in the event of a reorganization in 3.7, there wouldn't actually be a payment to Valsa or Vesa. And then I've also referred to the contra proferentum principle that any ambiguities at 56 should be resolved against the drafter. And again, there's a passage from Lewison there at 7.74 to 7.7 to 7.78. Now, finally, I wish to draw the distinction between what Mr. Knox says in terms of clause 5 of the clause 5 of the profit share agreement that deals expressly in a very, it is an entirely different context. Firstly, the Castellar land, which was then owned by VO7 and that in turn owned by Campo, was entirely undeveloped. So planning permission had been obtained, but no more. There were no minority interests, so that was fettering the other land. So this could be dealt with in an entirely different way. And as such, I say it was realistic for the sale to take place by selling the Castellar land itself, or the shares of VO7, or the shares in Campo, and that's why it was drafted in a different way. I've had to move rather slightly more quickly than I was anticipating, and I don't know if you have any further questions for me, my lady or my lords. And in terms of any...
I'll just ask you one question, which is troubling me, which is what would happen on your construction of the agreement if, instead of selling 100% of the shares in Soto, only a majority shareholding had been sold, no doubt producing a profit? Would that profit have to be shared pari passu with the...
Well, it would, and that, of course, could happen under 3.7 as well, because there could easily be a transfer, because that actually anticipates the transfer of shares, and so if only a transfer of, say, 75% of shares, then there would have to be that proportionate division.
Thank you.
Thank you very much.
Thank you, my lady.
Given the shortage of time, please do continue, Mr. Knox.
My lady, my lords, I have 3 points, if I can summarise them, and then I shall argue them and develop them, if I may just summarise them for the moment. First, I say the words of the profit share agreement are clear and unambiguous. The appellant is entitled to a profit share only in the event of a sale of the underlying properties, subject only to the provision of clause 3.7, where there has been a transfer of an underlying property to a company, and that company itself is then sold on. That, I submit, is the clear meaning of the words. And I say they're unambiguous, and that's where one stops. There's no need to go any further. But secondly, I say, in any event, the limitation to sales of underlying properties in clause 3 is explained by the context at the time the agreement was entered into in October 2012, namely the defendant's intention to be floated on the Channel Islands Stock Exchange and, importantly, to develop the individual properties in the next 5 years and then sell them off so as to make profits for essentially its investors before a final sale. There is therefore no basis for supposing that the limitation to the underlying properties is a mistake, especially as this is a professionally drawn contract. Nor, this is all part of the second point, nor is there any basis for reading the words in clause 3 more widely so as to entitle the appellant to a profit share even, and I emphasise this, even in the event of a bona fide sale of shares. In other words, not just some sort of cooked up arrangement. And there's no allegation in this case that this was a sort of cooked up arrangement to disguise the reality of a transfer of property. Thirdly, I say the limitation to sales of underlying properties, so far as material, does make good commercial sense. First, as a general point, Jaime Ortiz-Patino was in a perilous financial position, so it is not surprising that this agreement gives him only limited rights in relation to the sale of the Valsa properties. More limited, it must be noticed, than in relation to Campo, where he's given rather greater rights in relation to sale. I also say it gives, there is a commercial sense for this particular reason. It does give Mr. Ortiz-Patino certain limited rights, A, to require the defendant at least to look for buyers, and if it sells a property, or indeed all the properties, at a profit, to pay 9% of that profit to Mr. Ortiz-Patino, but importantly in accordance with the formula set out in Clause 3. It also gives him the right to ensure that a sale, an onward sale, and I say by necessary implication, is not artificially dressed up as a sale of shares, when in fact one can see from the underlying negotiations it was actually a sale of properties. I say there would probably be an implied term to prevent that, and I will take you to it later, but in Fox, I think my lady may be familiar with this case, in Martin and Morris, one of the points made by the Supreme Court is one can imply terms to prevent dirty tricks being played. And I would accept there would be an implied term to stop my client playing a dirty trick by dressing up a sale of an underlying property as a share sale in order to get out of an obligation. I accept that much. But...
Well, you don't need an implied term because haven't you got an express term?
Sorry?
You've got an express term which deals with at least with that in 3.7.
Yes.
What implied term are you envisaging that goes beyond the express term in 3.7?
Well, there may be no reorganisation at all. Because 3.7 we say applies only in the event of a reorganisation. Supposing what had happened was, let's say for the sake of example...
But a reorganisation would include, wouldn't it, putting an asset into a SPV for the purposes of sale?
Well, one could imagine this, my lord, I may be quibbling. One could imagine this, a sale of all 5 properties owned by Vessel. And that's negotiated as a sale of all properties owned by Vessel. There's no doubt about that. But then someone has the bright idea of saying, and everything's agreed, hey, tell you what, let's get out of that obligation to pay in relation to the underlying properties, because we can just sell Vessel at exactly the same price as all 5 properties. Supposing that had happened. In other words, a bad faith dressing up of a sale of underlying properties as a sale by, in this case, Vessel. I would accept if that had happened, if there's some sort of
Sorry,
bad...
you mean a sale of Vessel?
A sale of Vessel, yes. You just dress it up as a sale of Vessel.
It's not a dressed up sale, it's a sale of something different. But why do you accept, I'm just wondering, you accept, do you, that this profit share is triggered if there is a sale of the shares in Vessel?
No, I wouldn't accept that. What I would accept
I'm struggling to understand the factual scenario you're putting to us then.
Well, what I would say in those circumstances is there would be, the appellant would be able to say, you were able to and could have sold those 5 properties, those 4 properties, and to try to, and you were in a position to do so, but you have tried to get out of that obligation by dressing it up as a sale of Vessel, the shares in Vessel. But I am still entitled to...
I'm not being helped by this expression of dressing up. I mean, if somebody said, if Vessel had sold 5 individual properties which it owned, it is accepted that the profit share would be triggered on the sale of those 5 properties, correct?
That's right.
If, however, for entirely commercial reasons, the sale was structured as the sale of the shares in Vessel, the 94%, I think it's...
I think Vessel's 100%. And
100%, okay, Vessel's 100%. Okay, let's keep it that way. So if you sell instead the 100% of the shares in Vesa, you're accepting, are you, that that would trigger the profit share?
No, certainly not.
Well, why not? Well, what's the distinction between your, quote, dressing up and your naked sale of the shares in Vesa? I'm not understanding what dressing up it amounts to.
Well, because there will be, my lord, I submit there could be a difference, and this is one of the points taken in the Supreme Court in the Barton Morris case, between a genuine sale of the shares in Vesa, and there's no attempt to dress anything up. This is a genuine sale of the shares in Vesa, as opposed to, let us say, a negotiated sale of the 5 properties, and then someone says, "I tell you what, why don't we just jump out of our obligations and make this artificially make it a sale of the shares in Vesa."
Why do you, it's this artificiality or dressing up or whatever else. Is that purely premised upon the fact of the basis that there had previously been negotiations or agreement for the sale of these 5 properties?
Yes. Yeah. And supposing there was actually an agreement for the sale of the 5 properties, and then completion comes around, and then at completion someone says, "Why don't we just restructure this?"
But if somebody said for entirely other reasons, tax or otherwise, actually, can we just buy the shares in Vesa? So the parties negotiate for the sale of the 5 individual properties, and then some bright tax spark says, no, sell the shares in Vesa instead. It's much better for everybody. You wouldn't accept that a profit share is due.
No, I would not accept, because that's bona fide. There'd be a bona fide reason for that. It's simply where you enter into, you dress up a transaction. My lord, I know you quizzed me about that.
Well, it's because dressing up normally connotes making something appear that which it is not.
Exactly.
But in fact, the sale of shares would be exactly what it is.
Well, it would be, my lord, yes, but it would be entered into for bad faith reasons. In other words, I would accept there must be some implication to stop us acting in bad faith. I would accept that much.
Right, so,
If events occur in the other order and you're advised, because somebody's read the agreement, to effect any sale of the properties by way of a share sale, and that because it will avoid the obligation to pay the profit share, you don't. Do you accept or not?
No, I certainly don't. No.
So as long if you're told at the start, to pick up my lord's point, if you're told at the start by your advisors, look, I know they've come to you asking for sale of properties, but in fact, just talk about sale of the shares from the off, because you won't have to pay anything under the profit share agreement. You say that's perfectly okay.
That would be perfectly. That would not trigger. Come to another point if I may in a minute. That would not trigger the obligation per se. Entering into a share sale, this is my fundamental point, for whatever reason, subject possibly to bad faith, the bad faith point, but entering into a share sale does not trigger the obligation to pay 9% of the profits of whatever that share sale may possibly be worked out to be. What, however, could be said is this, but is very important to note in this case has not been said, is, let us take this example. Supposing there was a good market for the individual properties, let's say, let's take an example. Let's say also MGI don't even bother to look at the market. 3 months later, and there's a good market, and there is something where they don't, in other words, comply with their obligation to identify individual buyers for the individual properties. They just completely ignore that obligation. And what they then do is they then just say, right, I'm going to sell Valsa and Vesa, let's say. Now, in those circumstances, what the claimant could say is this, and this was the protection he's given. Look, you had at least the obligation to look around for buyers. What you've gone of the individual properties, but you haven't done that. You've therefore acted in breach of the agreement. And what you've gone and done is you've simply sold the properties, or rather the shares. But I'm still entitled to be put in the position that I would have been in had you identified buyers, I'm telling you there was a jolly good market, and acted in good faith having identified buyers and sold to those buyers. That was the right they had to require to require my client to look for buyers of the underlying properties. I submit that is the fundamental point in the case. If my client, in this case, it is not alleged that we did not look around for properties, or at least that we did not look around for properties, and had we done so, there would have been profits payable in accordance with the formula. And what essentially the appellant has sought to do is to jump from one right, which is the right to share in the sale of underlying property, to require us to identify individual purchases of individual properties, and then have a claim for damages if we fail to do so, is jumping from that to saying, well, no, I'm also entitled to share in the profits you make by a share sale. And I emphasize this again, even if the share sale is of SOTO itself. Is of SOTO itself.
Okay.
And so, my lady, my lords, that's what I submit, the protection that this agreement gives. And it is not an insubstantial protection, especially given everyone's understanding at the time that the properties were to be developed and sold. And that's why the agreement is structured as it is. And in those circumstances, let's take this example. Supposing it had been developed, let's say, and there's a very good market for all these lovely developed properties near the golf course, and we simply don't try to sell them. And we just decide, for whatever reason, to sell Balsa and Bessa, let's say, for the sake of example. Well, in those circumstances, what the claimant could say is, look, you acted in breach of your obligation to look for buyers of individual properties. And had you looked for that, you would have found lots of jolly good buyers, and I would have had a 9% profit as a result. That was their right. But they never had a right to share in the profits of a share sale, which is a quite different thing, and I do submit, manifestly not something for which the provisions of Clause 3 as a whole are designed to take into account at all. They are, my submission, unworkable in real life. You have to go through mental contortions to get Clause 3 as a whole working on a share sale, as opposed to on the sale of underlying properties. And I make that my third point, because it goes to the commerciality point, and indeed the absurdity point. I say that is the answer to the absurdity point. These are not worthless rights. If we try to be cute and just make share sales without looking for individual buyers of individual properties, we are in breach of the agreement. But that was not the case put against us, and indeed the judge notes as much. And that is a fundamental point in the case.
Thank you, Mr. Knox. I think in the circumstances, because it is important, I think, that we complete ground one today, that we should resume at 10 to 2.